Hello, everybody. My name is Jake Fritz, and along with Mohammed Al Dahab, Brendan Carney, Ben Eichner, Corey Hare, Ryan Kitte, and Laura Riley, we will be going over the Family and Medical Leave Act. Within our presentation, we are going to be giving you an overview of FMLA. More specifically, we are going to talk about who the FMLA applies to, some of the health conditions that are covered and not covered under the FMLA. We are also going to talk about how some states have different medical leave laws, and we are also going to give an analysis of some of the court cases that are involved with the FMLA, as well as what the overall public opinion of the Family and Medical Leave Act is in the United States of America.
What is the Family and Medical Leave Act, or FMLA for short? FMLA is an act that essentially helps eligible employees take unpaid job-protected leave for specific family and medical reasons with the continuation of their health insurance during these times of need and medical uncertainties. The act was passed in 1993 and it was signed by Bill Clinton under his administration, and it was enacted by the 103rd United States Congress. Essentially, FMLA can be as long as 12 weeks for serious medical issues or the need to take care of an immediate family member with serious health issues. Eligible employees must have worked for a covered employer. They must have worked for the employer for at least 12 months. They must have completed at least 1,250 hours of service for the employer during that 12-month period. And they also must work for an employer who has at least 50 employees within 75 miles. The process of being granted FMLA tends to follow a similar structure every time, and the structure looks kind of like the employee gives the employer notice of their need for FMLA, their absence. Then the company decides if they are eligible under the requirements for FMLA. Next, they determine if the leave request is qualified under FMLA, if it meets one of the reasons and conditions for it, and then they are either granted or denied the leave. Once the employee is on leave, the employer is legally obligated to maintain all health insurance benefits throughout, and upon return, these employees have to be restored their original job or a job of equivalency, equal pay, and equal benefits as to the job they left before. So that's a brief overview as to what the FMLA is and what it does.
Okay, so for who FMLA applies to, it's employees who obtain a physical disability that would further prohibit them from performing their daily tasks at an acceptable level. For an employee to meet the criteria, they had to have been employed for the prior 12 months, and during that prior 12 months, they had to have worked an accumulated 1,250 hours, and the employer itself must have 50 or more employees to be able to be considered an FMLA eligible job site. For example, of some FMLA people who can receive it, women who are given maternity leave to take care of a newborn or an adopted child, and that they are allotted 1 year of time off. People who are dealing with a severe illness in their immediate family, which in that case the amount of time off is determined by the employer. And although FMLA itself is unpaid, some employers will allot a specific number of hours that their employees get off that is paid to help take care of essential costs during emergencies. And as for right now, FMLA does not cover mental disabilities such as depression unless it has such an effect on the employee that they cannot perform their daily tasks. The fine line that sort of separates whether the mental condition is applicable or not is whether or not the employee is taking steps to improve the condition, and if they are and it's still too much, then they are able to receive FMLA from that.
The FMLA does not definitively say that certain illnesses and diseases aren't covered. However, certain common illnesses and diseases aren't usually covered by the FMLA. Some of these illnesses and diseases that usually aren't covered include cold and flu, earaches, upset stomach and minor ulcers, headaches except for migraines, routine dental and orthodontic work, cosmetic treatments unless complications arise, and other minor or short-term health issues. And even these conditions aren't automatically not covered by the FMLA. Every employee can be affected by these conditions differently, and what may seem minor to some may be a major health risk to others.
So with states with different medical leave laws, the FMLA sets the minimum standards for leave options, with each state allowed to provide more generous options when they feel necessary. So in 2018, a law that was provided up to 12 weeks of job protection pay leave in New York State was passed. This was the most inclusive paid family leave in the United States by covering new parents, family caregivers, and also military families with active deployment duties. On the other hand, Wisconsin's FMLA laws require employers to use the calendar year when measuring state leave eligibility, so the only one calendar year they're allowed. 12 states and Washington, D.C. have passed their own set of laws, while the federal law provides pay for workers to take time to bond with a new child, recover for mental and physical health, or take care of their ill loved ones. California, Connecticut, Hawaii, Maine, Massachusetts, Minnesota, New Jersey, New York, Oregon, Rhode Island, Vermont, and Washington State, along with Washington, D.C., have passed their own set of FMLA laws so far.
A few Supreme Court cases that were involving FMLA were Ragsdale versus Wolverine Worldwide, Nevada Department of HR versus Hibbs, and Coleman versus Court of Appeals of Maryland. In the first case, Ragsdale versus Wolverine Worldwide, or WWW, Ragsdale was an employee who was diagnosed with Hodgkin's disease, and during her treatment, Ragsdale requested and received her 30 weeks of paid leave. After the 30 weeks were up, she requested more unpaid sick leave, and WWW informed her that she had already exhausted her 7 months of leave provided under the company and denied her request, and that she was fired because she was unable to return to work. Under the amended regulation that came because of this case, an employer still must designate leave as an FMLA leave and provide an employee with timely notification. Now, an employer's failure to follow notice requirements may constitute an interference with an employee's FMLA rights that may make an employer liable for harms as a direct result of the violation. In the case of Nevada Department of HR versus Hibbs, it was considering whether a state could be sued under the FMLA. Hibbs was a Nevada agency employee who was authorized to take 12 weeks of intermittent FMLA leave over an 8-month period for a serious injury. He changed his intermittent leave to a full-time leave, and the Department of HR said that he violated FML and needed to come back to work at a certain time. When he was unable to, he was fired. The court's decision in this case specifically addressed the provisions of the FMLA permitting suits against an employer, including a state entity, for interference with an employee's FMLA rights to take a leave to take care of a spouse. In the final case of Coleman versus Court of Appeals of Maryland, Coleman was an employee who was sick and he requested FMLA, and he was told that he could not have it, he was denied it, and if he did not resign, he would be fired. He filed a lawsuit against the state saying he was denied FMLA. Justice Ginsburg ruled on this case that Coleman does not block injured employees from suing states for monetary relief, following state interference with an employee's FMLA rights. So this was also an amendment to the FMLA about when a state can and cannot be sued for denying FMLA rights.
So when it comes to the public opinion of FMLA, this is what we found. In 1996, the Center for Policy Alternative polled that 73% of people would prefer less pay if it provided such benefits found in FMLA. In 2013, a Pew poll found that 82% of Americans considered being able to take time off work to care for a child or other family member extremely or very important in a job. A PRRI poll from 2015 found that 82% of the public favored requiring companies to provide all full-time employees with paid leave for the birth or adoption of a child. And of that 82%, 44% felt strongly about that opinion. Nationally, it is a bipartisan issue to legislators, but they disagree on what to cover and how it should be funded. Small business owners are also supporting paid family and medical leave, but would prefer that the employers be allowed to choose whether or not they provide it.
In conclusion, the FMLA Act allows for eligible employees to take unpaid job-protected leave for specified family and medical reasons with the continuation of health insurance coverage. These eligible situations include the following things, such as the placement or birth of a child, the need for care for a spouse, child, or parent who has a serious medical condition, or having your own medical condition, or having a need related to the military and active duty being called. Basically, the FMLA Act can vary from state to state depending on the laws, but overall, the FMLA Act is in place to help people who have to take time off of their jobs to be able to still have the insurance that they need and still be able to know that their job is there for them when they come back.